Society. I'd like to welcome you to this morning's program, to today's program. I'll be very brief in my announcement since we're running just a couple of minutes behind. You will all have a binder of materials, of course, and in that binder you will have Harvey Spiegel's paper in the front flap. Unfortunately, due to a death in the family, Mr. Spiegel can't be here with us today. I'm going to look into the possibility, and at this moment it is only a possibility, that he would be available after a decent interval to tape his lecture, and if that's so, I will see that it's mailed out to each of you. At any rate, the written paper is in the binder. I also want to draw your attention to a question sheet. Please fill out any questions that you have on this sheet. You can simply leave it on the table. These will be collected at break times and dealt with in the question periods later on, or some at any rate of them will be dealt with in the question periods later on. And I appreciate your cooperation. I also wanted to draw your attention to something which will already be familiar to many of you, and that's the gray course evaluation form inside the binder. These are in significant measure what guide us in planning programming that will best meet your practice needs, and so you would be acting in your own self-interest as well as doing us a very great favor if you could complete those at some point towards the end of the day and leave them here before you go. If that proves impossible, then please do mail or fax them in. We read each one, we consider each one carefully. Your filling them out will not be in vain. I also wanted to take a moment to thank all our volunteer faculty, most of whom are as not yet visible, but all of whom certainly have contributed generously of their time and talents in preparing the materials you have today and in preparing the workshops and presentations that you will hear and participate in. We're completely dependent upon their efforts, and we're certainly very grateful to them. With no further ado, it gives me great pleasure to introduce Mark Orkin, whom I, like most of you, I'm sure know well as the author of Legal Ethics and the standard work, The Law of Costs. I didn't realize until reading the biography, which is contained in the materials, that he's also the author of that very famous book, Canadian A new edition of which will be coming out within the next year. Please join me in welcoming Mark Orkin. Thank you.
Okay. Good morning. Can everyone hear me? Good. As you can see from the prospectus, our program today is quite a substantial one. So I thought I might begin in a lighter vein by telling you a story, a fable rather. When they divided up the subjects for our seminar, someone gave me the topic that you see here, Overview of the Rules and Update on Government Privatization Initiatives. And someone else thought up the rest of the title, On a Clear Day, with its musical comedy associations. On a clear day you can see forever. I won't sing it. Having thought a little bit more about the subject, I came to the conclusion that the title of my talk should actually be, On a Clear Day You Can See No Place. And I'll tell you why. But first, the story. Those of you who are old enough to remember being taught Aesop's fables in school may recall the fable about the frogs who wanted a king. There the frogs were, living happily in the swamp, doing the things that swamp frogs do, sitting on lily pads, catching flies, making more of their kind, and so on. But with all that to enjoy, the frogs weren't happy. They wanted a king. So they prayed to the gods to send them down a king. And the gods, who always have a fine sense of humor, sent them down a log, a great, huge tree trunk that fell into the swamp with an enormous splash, sending out ripples as far as the frogs could see. Well, the frogs were overjoyed, and they paid proper respect and reverence to their new king. But after a while, the frogs became restless because the king never did anything. He never said anything. He just lay there. And the frogs began to complain. And this went on for a long time. frogs complaining about their do-nothing king. So they prayed to the gods to send them down another king. And the gods, maintaining the sense of humor for which gods are noted, sent them down a stork. And the stork promptly ate up all the frogs. End of fable. There's a moral in that fable for us as lawyers. For years and years, we've been living in our corner of the swamp, also known as the justice system, while growing progressively more and more unhappy with the way things were happening, or more accurately, were not happening. And you know what I mean, the delays, the backlogs, never knowing when your case is going to come on for trial. And all the while, our clients have been nipping at our heels, complaining about those same delays and backlogs and never knowing when their case was going to be reached for trial. And to make matters worse, complaining about the fees that we have to charge them for all that extra work because of the delays, the backlogs, and never knowing when our case is going to be ready for trial. Well, we've been grumbling about that for a long time, although we didn't pray very much for a king, because I guess the only prayers that lawyers utter are the prayers for relief in a statement of claim. But the gods, like our judges, sometimes act proprio motu, and they sent us down a king anyway. And the king's first words were common sense, amalgamation, downsizing, and of course, the P word, privatization. All that preamble brings me down to what may be going to happen to the assessment of solicitor and client costs in this province. If one can believe what we're told, the government is planning to privatize the assessment process, at least so far as concerns the assessment of solicitor and client costs. Initially, the idea seems to have been to do party and party costs as well, but fortunately someone thought better of it, and at least we can be thankful that that part of the system will remain in place. Why is this being done? Well, apparently it all fits into something called the minister's business plan. To quote some of their Queen's Park prose, its intention is to improve the delivery of services to the public by implementing leaner business structures, eliminating duplication of services, introducing new technology, and sharing resources with other justice partners. Don't know who they are. The business plan also stresses the ministry's intention to explore alternative methods of delivering some of the ministry's non-core services, which are currently provided through the court system. End of quote. The key words in all that baffle-gab, of course, are non-core services. In plain English, someone has decided that assessing lawyers' bills is not a key service, a core service, I should say, so let's dump it. What seems to have been bothering the ministry is that, according to them, the assessment office is costing $1 million a year to operate, while at the same time it only takes in a measly $250,000 in filing fees. So in their books, that would indicate a deficit of $750,000. As well, the ministry people say that they're concerned with the delays, backlogs, and never knowing when your cases, we've all been through that, and other inefficiencies of the system. And I'm with them there, of course, but would have thought in my innocence that the remedy was to beef up the system. The next problem for the ministry is that, according to them, there are 6,000 or 7,000 requests annually for assessments. 80% of them, they say, instigated by lawyers. And the reasoning seems to be this: why should we spend $1 million a year to help lawyers collect their bills? In passing, one assessment officer whom I spoke to said that in his experience, 80% of the 80% figure for lawyer-instigated assessments is way off the mark. I'm not going to get into that argument. And also, no one is sure how they arrived at the yearly cost figure of $1 million to run the assessment office, because everybody knows, if you visited 145 Queen Street West lately that the place is running on empty. The assessment officers occupy part of one floor of an almost derelict building, while the rest of the place is abandoned and in darkness. The entire visible staff the day I was there was one commissionaire dozing near the front door. If the ministry is really spending $1 million a year for that chintzy operation, they're getting cheated. Another thought, no doubt unworthy, is that they're letting the assessment machinery deteriorate to the point where its inability to function adequately will be a perfectly good excuse to demolish it. Whatever the reason, the ministry's game plan seems to be to shut down the assessment office as we know it. And by the look of 145 Queen Street West, they're 3/4 of the way there already. And they're going to replace it with what they call a fee-for-service system. The idea is to turn over responsibility for all solicitor and client assessments to what the ministry calls private sector service providers. A nice bureaucratic touch, that, who would be paid directly by the parties themselves. How would this work? As I understand it, and so far, these seem to be proposals only, so don't hold me to it. The new system would be coupled with a mediation process, possibly on a voluntary basis. If that comes about, parties would be encouraged to seek mediation before proceeding to an assessment. If the parties decline mediation or are unable to resolve their fee disputes despite using mediation, then they would apply to the local court office for an assessment order in much the same way as is done currently. They would then be directed to what is referred to as a roster of fee-for-service private sector assessment officers who would be paid for by the parties themselves according to a fee schedule still to be developed. Seemingly, although this isn't too clear, the present practices and procedures would continue to be in effect. Now, if that is the shape of things to come in the assessment office, and we don't really know quite what the shape is yet, but it seems to me there are many questions left unanswered by that program, and I venture to suggest a few answers of my own. Question number one, can all this be done without amending the Solicitors Act? The ministry seems to think it can. I think it can't. Question number two, how will privatizing a section of the justice system sit with the Charter? Or if not the Charter, how about Magna Carta? Answer, I wouldn't be at all surprised to see a court challenge. Everybody knows that for litigation lawyers, court challenges are like, Charter challenges are like catnip to a cat. Question number three, can one reasonably expect that a private system will be A, any better, or B, any more efficient than the present one? Answer, I doubt it. Question number four, how are John and Joan Q. Public going to react when they find that instead of getting an assessment for $53, admittedly a bargain, they would have to shell out possibly hundreds and hundreds of dollars to pay for the services of a private assessment officer? Answer, they will be even more unhappy than they are now with the present system. Question number five, how will said John and Joan react when they discover that their lawyer's bill is being assessed not by an independent judicial officer operating within the court system, but by a private assessor, quite likely another lawyer? Answer, they will probably see it as another case of lawyers protecting lawyers, and they won't like it. Question number six, are lawyers themselves going to buy the idea? Answer, my guess would be that they will probably stick to what they know and sue their clients in civil court, which would mean, if the 80% figure holds true, that the court system would be burdened with another 4,000 or 5,000 cases a year, or more if the clients take the same road, which I expect they will do. Question number seven, How are the judges going to feel when 4,000 or 5,000 or more assessments a year are dropped into their laps? Answer, unhappy. Question number 8. If the problem is that the assessment system is costing more money than it takes in, why not raise the price of admission? Answer, too easy and too practical for government. Since we're talking common sense, it costs $132 to issue a statement of claim. Why not charge a like amount for an assessment order? Very often there's more involved in an assessment than there is in the average small piece of litigation. If my math is right, then 7,000 assessment orders a year at the new price would raise $942,000 in fees for the government, which would almost wipe out that deficit. Speaking seriously now, it's just not possible to deal with the specifics of what's in the cards for the assessment process. And I wish I could be more definite about it, but I can't, and no one else can either. The ministry appears committed to this initiative, as it is to a number of other changes to the justice system and elsewhere with which I'm sure you're familiar. The problem is that we do not yet have any clear idea of what the new process will be, or when it will be introduced, or how it will operate when it is introduced. I have no doubt that whatever happens, we lawyers will accommodate to it because we're good at that. But in the meantime, you now know as much about it as I do, which ain't much. Finally, I would not want you to take from some of my earlier remarks this morning that this is anything but a serious matter. Unfortunately, this proposed change to a small corner of the justice system doesn't have the public resonance of other government initiatives, such as the amalgamation of municipalities or the closing of hospitals. But in the context of the administration of justice, and more important, its perception by the public, it will be just as significant. For that reason, last fall, Canadian Bar Association Ontario, CBAO, set up a special committee to formulate and make representations to the government on this important matter. I am a member of that committee, and therefore I declare my interest. But I speak only for myself today and not on behalf of the committee, to whom I did not submit these remarks in advance. However, I can tell you that along with representatives from the Law Society and the Advocate Society, they're hoping to have some influence on the government before the proposed changes are set in stone. I know that they will appreciate your interest and support for something that will affect each one of us. With that in mind, we will now proceed with the rest of this morning's program. Thank you. As you've been told, regrettably, Harvey Spiegel can't be here due to the death in the family. He has been good enough to send along his material, and Ed Upenieks is going to have a run at it on very short notice, which is totally commendable. First, though, I'd like to call on Ed to deal with his scheduled, or if you prefer, scheduled presentation, which is all your ducks in a row preparing for the hearing. Ed? I don't have to give them a CV because I see they've already put them in the book. If you care to turn up and find out this man who's going to talk to you, he's somewhere in here. End of tab 2. I could read it to you, but we've been told we're not to read something that you already have. Ed, would you carry on?
Would you like to sit here?
Thank you. Now that Mark has everybody's attention, I'm going to see if I can keep your attention. You've heard what's been going on behind the scenes in relation to assessments of cost and what may or may not be coming. And certainly we've learned that Mr. Orkin has very strong views. I happen to share those views, and one of the items that he didn't mention, the government indicated that it's $1 million that it costs. There's been no statistic that's been available to back that up. But let me tell you about preparation for the assessment, the way the system currently works. And what I'm going to do is run through it, whether you're acting for the client, whether you're acting for the solicitor, or some considerations that apply to either. You'll see that there's a paper that I prepared that's in the material, and what I've brought along as well are some overheads for today that I'll go through, just some sample dockets so you get an idea of how I prepare, and it's not the best system or the only system, it's just the system that I happen to use. First, the importance of preparation. In my view, it's crucial because assessments of cost, solicitor and client assessments of cost, are a different animal totally than what we're used to in the litigation process. There's no real pleadings, there's no affidavits of documents, there's no discoveries, and often it can be like a trial by ambush situation. But what you do have to go on, you should use. And one of those items is the dockets, and that's why I've brought along just some sample dockets. And I know it's been said before that preparation is crucial for a result in litigation, and I think it's even more so for assessments of cost because of the particular nature of assessments of cost. And I'd say it's at least 90% preparation. Before you get to the assessment of costs, probably 90% of your time should have been spent already going through the dockets and preparing your argument. And I think preparation really affects the outcome of the assessment. And we've all read cases where there's been a huge reduction. You want to avoid that. And what I've brought along for you is a quote from a case. This is an unreported case from 1971. And this is the sort of situation that you want to avoid. Again, it should be apparent that to approach a consideration of the reasonableness of a solicitor's fee from the direction of nothing more than an assessment of the propriety in general of his hourly rate would be to endorse the efforts of the slow, methodical, unimaginative, unenthusiastic, nitpicking plotter, the intellectual drudge of the legal profession. Although the intentions and motives of such a person are usually beyond criticism, it is simply not arguable, at least in this forum, that he should be offered what would be in effect a bonus for managing to do in, say, 10 hours what a solicitor of modest experience and reasonable resourcefulness could do in 5. That's what we want to avoid when acting for the solicitor. And before I get into the meat of the presentation, I just want to ask a show of hands. Firstly, the lawyers here, how many now have an assessment that's pending? They have an appointment now? Okay, and how many have been on an assessment of costs in the past? Oh, so pretty well everybody's been on an assessment in the past, and about half have one pending. Now, what I want to do firstly is just some considerations when acting for the client, and I want to start with some preliminary considerations. First thing, say the solicitor takes out the appointment, and there's a government statistic that about 70 or 80% of the cases, that's the way it starts. There's an appointment, you receive the appointment, client gives it to you. Always check with the assessment office how much time has been set aside, because sometimes there's cases, $100,000 assessment, there's an hour set aside. If it's contested, that simply isn't enough time. Find out how much time is set aside, and then if you think that it's not enough, right away to the other solicitor and advise them that you think there should be more time set aside, and maybe you can get a proper appointment. But don't wait. Don't wait until the eve of the assessment and then ask for an adjournment for all sorts of reasons, including the fact that you think more time should be set aside. A second item, the proper client. What has happened in the past, there's been an appointment that's taken out in a situation where work is done for a closely held company or an entrepreneur. The bills go to the company, and perhaps the lawyer realizes that the company doesn't have assets or has nominal assets, then somehow an appointment is taken out naming the individual as the client. Well, that should be dealt with right away. Another item that you should deal with right away is any dispute as to the retainer. So the typical situation is where the client is asserting, well, I never even retained the lawyer to do any of this. If there is that sort of a dispute, you have to deal with it right away, and the way you deal with it is to bring a motion. You don't leave it to the assessment of cost, but you bring a motion in advance, and you bring a motion in advance to a master to deal with the question of the retainer, because an assessment officer can't deal with that question. Was there a retainer or not? Another item that you should deal with initially is service. The Solicitors Act provides for due notice to the client. You have to make sure that the client received proper notice. And a last item, and I've seen this come up many, many times, is all the accounts should be included with the appointment for the assessment. It's in what often happens, you might have a series of 10 or 12 accounts, and the appointment is taken out for the 1 or 2 that haven't been paid. Earlier accounts were paid. Well, they should all be assessed. They should all be included as part of the material for the order for the appointment for the assessment of costs. Okay, those are just some preliminary items. Now, in terms of preparation, when you're acting for the client, what are the things that you should do and in what order? Firstly, I think it's important to get the client's file. And depending on the client, this could be very complete or it could be very, very sketchy. But you want to read that first, just to get an idea of what's involved in the file. Next, you want to interview the client and find out what the real concerns are. Was there a lack of communication? Is he concerned about the result? Is he concerned about the global amount of the fee? Things like that. Next, review the dockets, and this is probably a very important part of it. And sometimes you don't even have the dockets. Sometimes solicitors do send along dockets with accounts, or sometimes they send it along with the appointment. But if you don't have the dockets, that should be one of the first things that you ask for. Get the solicitor's dockets. And when you do get them, you have to closely inspect them. Look for any errors in the dockets, look for any inconsistencies, and start planning your strategy for the assessment. Now, I've brought along just some samples, and this is what okay. Now, all the dockets don't look like this, but typically this is the sort of thing that you see. And when you get the dockets, you want to start going through them quickly just to get a general sense, page after page, of what was done, and then start analyzing them in more detail. Now, typically dockets have this sort of a description: the date, the description of the activity, the lawyer, the number of hours. Sometimes there's the hourly rate, but not always. The hourly rate isn't always on there. The value, which is just the product of the number of hours times the hourly rate, and then an internal computer number, which I think is typically the order that the dockets are put into the system. Now, when you do a more detailed analysis, the sort of things that I would look to here, and I'll just try to go through them bit by bit. Firstly, there's a docket for January 1st of 1997, which is kind of an odd day, but if you're getting ready for trial. Next, the hours involved. You've got 5 hours, and you'd be concerned that it was 5 hours and not 3.5, or not 4 hours, or not some other amount. It's a round amount. And then continuing on, we start coming to in-house conferences. In-house conferences, and just the code that I've got is first the senior lawyer, 0.5 hours. Then the junior, 0.6 hours. And then the same day we've got research by the junior for 4 hours. And one thing that I found is research is an important area to look at, because sometimes there are a lot of dockets put under research. So here you've got a junior spending 4 hours. Research, we don't know what's being researched. January 1st, searching by a student, 2 hours. We don't know what's being searched, but we have a docket entry for 2 hours. Continuing on, in-house conference, junior 0.4 hours with a student. Sorry. Another in-house conference, then a research, new file, 8 hours. Okay, now in terms of just the last docket entry, you'd want to know when you inspect the file, what was researched? There's 8 hours. You would want to find out if there was a memo that was produced. You know, what was done for the 8 hours? Someone should have to account for that. And then continuing on in the sequence, we have more, January 3rd, there's more research again. Student 5 hours. Then January 3rd, there's an in-house conference or a lunch. Okay, we have a student docketing 1.5 hours, senior docketing 0.5 hours, junior docketing 1 hour. So there's a bit of an inconsistency there. Was it a meeting? Was it a lunch? Was it a combination? How much time was really spent on it? January 3rd, student 3 hours research, photocopy cases. Well, one of the things that I would argue on this is, isn't that some overhead? Why should the client charge for a student to photocopy cases? Often there's a perfectly good explanation. Cases that could only be obtained from the Great Library, for example, but the argument when you're acting for the client is, isn't this part of overhead? Couldn't a secretary, for example, do this work? Next, a similar entry, research typing memorandum of law. The students give an extra description of the research. Well, again, couldn't this or shouldn't this possibly be part of the normal overhead of the firm? And then we have solicitor's time to review the student's memorandum, 1.5 hours. Okay, then continuing on, January 3rd, revising memorandum. Okay, students spending 1.4 hours. The first student spending 1.4 hours. Same day, there's another student involved. Okay, so now we've got a senior lawyer, junior lawyer, 2 students involved. 2 students are doing research. Second student is assisting with the misrepresentation issue. And then January 4th, 5th, and 6th, we have the senior docketing 8 hours. January 4th, preparation for trial all day. The next day, docketing the same amount, 8 hours, again for preparation for trial all day. And again, the third day, 8 hours. It's not 7 hours, not 8.5, but it's 8 hours 3 times in a row. And something that you might have picked up on, the audit number, which is the sequencing number, this one's out of sequence. Okay, so the docket was put in later on. It was put in the first page of the dockets. They started at 4,501. This is put in later on, and that's something that you just want to keep in the back of your head to find out, are there some dockets going in later on? And if a docketer puts in all their dockets after the fact, that's no big deal. But what you want to look for is they put in some dockets in the proper order, and then afterwards they go back and put some in after the fact, and they're big docket entries. That's the sort of thing that you might look to. And keep in mind when you inspect their file. Next, trial preparation. And you have a few in-house conferences. The junior, the student on January 6th, 0.2 hours. Student docketing 1 hour when there's a docket for 0.2. Okay, and then continuing on, there's a second student was in on the meeting on January the 6th again. So you're starting to ask yourself, is it necessary to have a junior, a senior, one student, and a second student all in on the same meeting? It depends on the file, but that's the sort of thing that you want to look for in the dockets. January 6th, complete research memorandum and photocopy. Again, there might be some element of overhead that you may or may not want to bring up later on. January 6th, the first junior is briefing a second junior. Well, that's something that you might want to potentially find out about. Why is there another junior involved? The next docket gives a clue, possible scheduling problem. So internally, perhaps there's a trial date and the first junior is concerned, maybe he can't keep the trial date. Next, prepare for Court of Appeal, January 6th. This looks to me like a missed docket. It's probably charged to the wrong file. This involves preparation for a trial. Here's a docket. Prepare for Court of Appeal. It should have been in on another file. Okay? That's the sort of thing that you look for in the dockets. And next, research misrepresentations. There's further research, 3 hours on January the 6th. And if we go back, okay, to the very first doc. Remember I mentioned the sequence? This is the first docket page. And the audit numbers down the far right-hand side, we see that there's a difference in the audit numbers for the senior lawyer. 4721 on January 1st, and later on they're 4500s. Okay? You may or may not bring it up, but that's something that you should notice and follow up when you review the file itself. Okay, just continuing on with some of the other items. Reviewing dockets is important, and I just ran through an illustration of some of the sort of things that you look for. And this is a preliminary review of the dockets. I don't think it's necessary to spend hours and hours poring over dockets, but I think typically the problem is that sometimes we don't spend enough time. Sometimes we just spend a minute or two, but often there's a lot buried in the dockets that can be useful for the assessment itself. Now, typically, I found that we do look at the dockets, we ask for the dockets, but something that we don't do, and I think we should do, is ask to inspect the solicitor's file. Often that's not done, and I think you should always ask to see the solicitor's file, but do it after you've seen the dockets. And then you have things that you want to start to look for. For example, in this case, in the case I looked at, I think there was about 28 or 29 hours of research. When you inspect the lawyer's file, look for the research. There should be a research file.
Do you have a right to inspect the lawyer's file?
I've found I always ask for it, and it's probably about 10 or 20% of the time there's some challenge. What I usually want to do, I just want to go over and inspect it at the lawyer's office. When there is a challenge, I put it in writing, and in my experience in 13 years, I've brought 2 motions. And both times before the motion was brought, the other side recapitulated. But I think that it's crucial to see the file because the lawyer is going to be bringing the file to the assessment, okay? That's really like the affidavit of documents. That's the listing of all the documents that they have. I think you have to see it. Now, the other sorts of things that you look for example, when you've got 28 or 29 hours just in a short time frame, you want to see the cases that constitute the research or a memorandum. And if there isn't a memorandum, that's something that you can bring up at the assessment of cost. 28 hours docketed in 6 days, and you couldn't find a memorandum of law. I mean, there's answers on the other side as well, but that's the sort of thing that you look for. And also look for docketing errors. There's one that I pointed out, Court of Appeal seemed to be a missed docket. Satisfy yourself whether that is or is not the case. Continuing on, acting for the client, some other things that you should do, prepare a chronology. I think a chronology is also always useful so that you know the significant events and you know where they fit in. Consider whether you want the client to testify. And I think this is important, especially where you have a client who's particularly anxious to testify, and you think may be a difficult client. You could be sinking the client if you permit them to testify, because the lawyer no doubt is going to be saying, this was a very difficult client, and it'll hit home when they testify. Prepare a brief of important documents. When acting for the client, this would include, for example, any letters that the client has written to the solicitor, asking for information, commenting on failure to communicate, maybe complaining about the fee, but put it in a package and have it available for the start of the assessment. Something that you should always bear in mind as well is your retainer. You're acting for a client here challenging a lawyer's bill. Or the client has had a problem, he or she has had a problem with the solicitor already. Make sure you're not the second solicitor who has a problem with this client. And especially if they have a good result, if the matter does not settle and you go through on the assessment of costs, they might end up liking the assessment process. And they may just be chomping at the bit. They may think that they're going to do it themselves the next time. So always bear that in mind as well. And lastly, but very importantly, offers to settle. In my view, you should always get instructions for an offer to settle, but you can't put in your offer to settle until you've carefully reviewed the dockets and until you've had the opportunity to go through the solicitor's file. But you should always try to get instructions for that. I've spent most of the time dealing with the situation where you're acting for the client. When you're acting for the solicitor, there are some overlapping concerns, and I'm just going to outline perhaps some of the main concerns when you're acting for the solicitor or acting for yourself. Firstly, when you're acting for the solicitor, read the solicitor's file. That should be the first thing that you do. And you don't have to read every page and every document, but you want to get a general sense of what's in there. And then always read it critically. Read it as though you are challenging the account. What would you challenge? And then take that up with the solicitor. Take up the docket entries that seem to be done in error. Why was so much research time spent? Why is there no memorandum of law? Why are there no cases? It may be that there are no cases directly on point. That's why so much time was spent. But find out about that and get the answers early on. Organize the solicitor's file. I can remember a couple instances where I was retained on behalf of the solicitor, and they brought in a file. It was just, thank God the Law Society didn't see these. They're just a mess. Like, stuff's all over. Nothing's organized. And of course, one of the client complaints was that the lawyer wasn't organized. Well, for sure, the very first thing, even before I read it, I had it organized. I had it organized the way I thought the file should have been kept. And that's the way that the file was brought to the assessment of cost. Don't bring it with papers all over and notes that are just loose, pleadings that are with correspondence and documents that are with correspondence. That's not what you want to present at the assessment of costs. When acting for the Solicitor, Evidence Act notices under Section 35, that's the section that deals with business records that are kept in the normal course. You can serve a notice for your dockets, and that helps in a situation where there are a lot of people involved in the file, and especially clerks and students. You don't want to necessarily call everybody to testify. Certainly the main lawyer has to testify, but this is one way of dealing with the time spent by others. And again, a brief of important documents. Now, the solicitor often wants other documents in there. If the case that you're dealing with was reported, put in the actual reported case. Put in any correspondence that you think is helpful for the assessment of costs. So it's before the assessment officer right off the bat. Also, I wanted to touch on some items that you might want to include regardless of whether you're acting for the client or acting for the solicitors, or some items that you want to deal with. One of them is a trust reconciliation. I think it's embarrassing if you're on an assessment of costs and one of the first questions is, what's the total of the accounts? The solicitor doesn't know, the client or the client solicitor, they don't know either. That should be dealt with, and that's something that you can have support staff do. There's no reason that it can't be done right off the bat. And interest calculations, usually if you're acting for the solicitor, you're of course asking for interest. Now, if there's a series of accounts and a series of payments, sometimes it gets complicated as to how much interest is awarded. Well, what you can do is prepare calculations in advance, and I know the way that I try to do them is do them based on 1 month after the account was sent, and then do it on a notional amount like 10%. And the reason I choose 10%, it's easy to deal with. So if there's an award of 6% or 7%, it's easy to adjust, and you have the right number of days if you do it on each individual account, as opposed to everybody spending time at the assessment trying to figure out the amount. Next, analysis of disbursements. When you're acting for the client, you should let the other side know in advance which disbursements you don't challenge at all. And when you're acting for the solicitor, likewise, you want to know right off the bat which ones are or are not an issue. And a caveat when you're acting on your own behalf or acting on behalf of the solicitor, experts' costs. It's not like photocopies. You have to prove the experts' costs. Okay, so it's not enough to just file the to file an invoice from the expert and expect that that's all you have to ready yourself for the assessment. If there's a big expert's bill, you want to contact the expert and make sure that they're available, if need be, for the assessment of costs.
On that point, though, if the client has paid for the expert bill, even though you may retain the expert for the client pays direct, that wouldn't come into the assessment process, would it?
If it's not a part of the bill, if it's not listed as a disbursement, no, in my view. And just in closing on this, I've outlined some of the items that I look for on an assessment of costs, and hopefully I've mentioned one or two that perhaps you haven't considered or used in the past. It seems like a lot of people have pending assessments. Try to, if you have enough time, to do the things that I mentioned, and especially if you're challenging a bill, to inspect the lawyer's file. You don't need to spend days on end going through the file, but I think that it's a very useful exercise. And I think that generally, we in the legal profession, and I know it's true in our firm, as I'm sure it is elsewhere, there's a lot of uncertainty about how you prepare for assessments of cost, because there isn't very much written material. So hopefully we've reduced in some little way some of the uncertainty, and you know some of the things that you perhaps you should be asking for, and hopefully you're a little bit more familiar with the preparation, and hopefully you'll all prepare properly now. Okay, I'm going to move back here for the next part.
Thank you, Ed. I might just add one or 2 points of my own, if I may, to what that very, very helpful presentation. One is a lesson that I learned a long time ago from Bill McBride, who was a great assessment officer in his day, now regrettably long gone. And he told me once, the first thing he does when he has a solicitor's bill in front of him for assessment is check the arithmetic. He said, you would not believe how many lawyers can't add. And if you're acting for the lawyer, you should protect yourself in advance. If there are any errors, you can bring them to the assessment officer's attention immediately. If you're acting for the client, it's a cute ploy because you can throw him off balance by attacking his arithmetic. And the second point I have, and Ed touched on this, I think in a general way, I found it very helpful to do a spreadsheet, particularly when there are a lot of bills. Doesn't matter whether you're acting for the lawyer or the client, so that it's all there on one page. You can see the bills broken down into fees, disbursements, GST, and totals. So if you're acting for the lawyer, the total doesn't look too awful because you've segregated out the fees portion. But it's very, very helpful. Saves an awful lot of work in introducing. Otherwise, you dump a wad of bills attached to an assessment order in front of the assessment officer, who then has to figure it all out. So it's very helpful for yourself and very helpful for the assessment officer to do it on a spreadsheet. Those are my comments. Ed has been good enough, as I mentioned earlier, to take a shot at Harvey Spiegel's presentation, and we'll wait and see what happens.
Just before I do that, those were excellent points. In relation to the arithmetic, you should always have a calculator with you. Always take a calculator, because to a large extent, the assessment is a mathematical exercise, and sometimes there's multiplication and division too. So it's helpful if you have your calculator. And that reminds me of the very first assessment that I did, and this is before most firms had computerized dockets. There was a lawyer who was charging for about 2 years worth of work for a client. I was acting for the client, and he had a lump sum, and it was something like $35,000 for one account, $15,000 for another. And he didn't, I wasn't smart enough then to ask for dockets, and he just brought along his dockets at the assessment, and I was trying to race through them, and it didn't seem right to me. So I asked for a total, and he didn't want to give a total in evidence. So I got the total, and I stretched it out until a break, and then over the break I added it up on my calculator, and you know what, there was a significant error. So when we came back, the first thing I mentioned is that, look, I'm sorry I didn't do this before, but I just added it up, and there's a 30% error here. And the lawyer turned red, and he acknowledged, yes, that there's more. He gave more hours than there actually were dockets, and I think that was the beginning of the end. Now, that's probably when I first learned the importance of doing your preparation, but at least I got the opportunity to do the math at the hearing. And just the other point, too, on spreadsheets, that's a very useful comment for the fees, disbursements, and also you can do a similar analysis for example, research. If you've gone through page after page and you've come up with not 28 hours but 128 hours of research, you can do a spreadsheet that indicates how much research time was spent by the different docketers. And if you present that to the assessment officer, sometimes that's very, very powerful. And likewise with in-house conferences. If there's a lot of in-house conferences, do a little chart that lists the in-house conferences and the total time spent, and then you come up with not only duplication but triplication of effort, the same people docketing, the same sort of thing. Anyway, if I can deal with the retainer article prepared by Mr. Spiegel. And I think that an important thing that we can all glean from this is that it's very important to have a retainer agreement to avoid legal conflicts. On occasion, you can totally avoid a conflict if you have the retainer agreement, or where you do have a dispute or a conflict, sometimes it can facilitate the resolution of the conflict. In his article, he deals with defining retainer agreements, and really all it is just the act of employing a solicitor to perform a particular service. Now, you can have an oral or a written agreement, but more and more it's been shown in the reported cases that you have a problem if you have, or you can have a problem if you have an oral agreement. As a solicitor, you should, as a matter of course, have a written agreement. And in terms of the written agreement, there's case law to the effect that it should be very explicit. And some of the items that have been mentioned in the case law for the retainer agreement are an estimate of the fees. Now, in litigation matters, that's very difficult to do, but you can indicate the hourly rate, and you can do that by way of a schedule attached to the retainer agreement, listing the hourly rates. But a caveat here, if you do that, make sure when the hourly rates change, a lot of firms aren't changing the hourly rates now, but when they do change, often it's done once a year. As a matter of course, you should send out something to all your clients that have a retainer agreement advising them of the new hourly rate, because there is case law that indicates if you don't, you're stuck with the earlier amount. Actually, maybe we can wait till the end when Mr. Orkin will chair a series of questions, written and oral questions. In your retainer agreement, something else that I suggest you do is you describe why you were retained, and it can be a general description, but again, be as explicit as you possibly can. Describe the scope of the work, and you might want to include some parameters, some other parameters, such as a premium for success, or a premium if the matter ends up being particularly complex. Now, if it is a detailed retainer agreement, you might want to consider whether the client should get independent legal advice. Certainly, if it's a long retainer agreement and it's a big file, that's something you should look at very closely. And another item that you should always bear in mind is if there are any unusual or special circumstances during the file, make sure you tell the client about it. If you've envisaged the matter would proceed a certain way, if you've envisaged a straightforward corporate deal and it changes, put that in writing. Or you've envisaged a straightforward house transaction, it changes, put it in writing. Likewise with litigation. If you're being motioned to death, make sure the client knows about that. And one of the important premises from Mr. Spiegel's paper as well is failure to communicate. He indicates that so often the real complaint that the client has is the failure to communicate, the failure to be kept advised. And he suggests that you send pleadings and almost all your correspondence to the client, and that probably is a good practice. They'll tell you if they don't want to receive a lot of paper, but typically they welcome it. They like to receive the paper. They like to know what's going on. Now, he deals in his paper with a situation that involved a famous criminal trial involving Mr. Bucksbaum, where the solicitor was Mr. Greenspan, and there was an agreement. Mr. Greenspan had an initial retainer, and this was back more than a decade ago, of $30,000, and he had a retainer agreement signed by Mr. Bucksbaum, and he was having the agreement assessed, I believe, in Windsor. So he had the assessment officer deal with each account, and he'd have an affidavit from Mr. Bucksbaum in each instance indicating, I'm content with this. And an issue came up in the end after the preliminary and after the trial. Mr. Bucksbaum was convicted, and he'd paid over $1 million in fees. There was still about $165,000 unpaid, and all of a sudden he wasn't content with the old agreement, and he wanted it reopened, and Mr. Greenspan retained Mr. Sapinka, I believe it was, and Mr. Bucksbaum retained Mr. Carthy, as he then was, as his counsel, and we had an interesting motion. Now, unfortunately, Mr. Justice Hughes didn't deal with the issue. Really, on a technicality, he skirted the issue, saying that we don't come under the specific provisions of the Solicitor Act that deal with a situation like this, and also because the account had not been paid in full. So that would have been a terrific opportunity to deal with this type of situation. But the paper, you'll see when you read through it in the next week, as I hope you will, it deals with the fact that maybe solicitors should be trying to get pre-approval of agreements for lengthy, complicated matters. $1 million fee, that was a perfect case to do it. If there's a lengthy criminal matter, lengthy construction lien matter, you want to get the agreement approved by the assessment office in advance. Now, unfortunately, we don't have a terrific precedent in Ontario on point. But that's something that I hope you keep in the back of your mind, that the Solicitors Act, and I know a lot of us haven't looked at it very many times, but there are a lot of sections that deal with that type of situation. So always keep that in mind. In relation to litigious matters, except for the small claims court, you can't, in Ontario, have an agreement for a percentage fee. And other than that, I think that's pretty well it from what I want to say in relation to the article and the question of retainer agreements.
Thank you, Ed. The only thing I could add to that, and Harvey Spiegel's presentation in his text is really very comprehensive. He deals at great length, I know, because although I haven't read it, I discussed it with him on the telephone, with the whole business of agreements with your client about fees, which is really the back 2/3, if not 3/4 of the Solicitors Act, which no one ever reads, and which has rarely, if ever, been adequately looked at by the courts. Harvey does a very good presentation of that. The only thing I'd add to Ed's comments, perhaps, are these. I agree with him about the importance of a retainer. Very often, for whatever reason, a retainer isn't signed. Either you don't do one, or the client doesn't sign it, or you send it to him and the client doesn't send it back, whatever. confirm by letter the terms of the retainer. Whether the client signs something or not, doesn't matter. That's good enough. If you then proceed to represent the client, for all practical purposes, your letter will serve as a retainer because the client has, in effect, adopted it by continuing to use your services. The other thing which Ed touched on was this business of a premium, sometimes inelegantly called a bonus. There are no end of cases on when a lawyer is entitled to a bonus, and they're really all over the lot. There are cases in Ontario, cases in British Columbia, and all one can say is that if you're going to, if you anticipate that this may be a situation where you will be entitled to a bonus for, an unusually good result, let's say, then you should cover that in your retainer with your client. If you don't want to talk about bonuses, which may put some people off, then at least point out to them that although these are your hourly rates and the hourly rates of various members of your staff, your fee will be determined at the end by all the considerations, including the result obtained. And that gives you a foot in the door if you have to argue bonus or premium at the end of the day before the assessment officer. I think we're going to have to break a little early for coffee, but perhaps no one will mind that. And when we resume, Grace Maitland-Carter will be giving her view on the assessment process. Thank you very much.